All right, good morning again from our Fox 9 streaming center. You've, of course, been watching our gavel coverage of the Apple River stabbing trial from Hudson, Wisconsin. St. Croix County District Attorney Carl Anderson delivering a strong closing argument to this jury, asking the jury to find Nikolai Miu guilty on all of the top counts. He said he's not going to defend the actions of the Stillwater teens. Their behavior appalling. Inappropriate on the river, but it does not justify what Nikolai Miu did. Anderson calling it senseless, asking the question rhetorically, why didn't Nikolai Miu just walk away? He points out the made-up stories, the lies afterwards. He says Miu did that because he knew what he did in that moment was wrong, that it wasn't justified. Nikolai throwing the first punch, hitting Madison Cohen, describing Miu as not feeble, looked past the quadruple bypass that he had recently experienced in his life. Don't look at this as a 13 versus 1. This was 2v1 at most. The 13 were sort of all around, but certainly not in Miu's face at the time. He points out that Wisconsin is not a stand-your-ground state. He has no duty to retreat, and then pointing out the severity of Isaac's injuries, puncturing or shattering through 2 ribs and stabbing Isaac Schumann, killing him with the knife to the heart. Quote, Nikolai was angry, he snapped. Nikolai was not scared, he was angry, he snapped. Let me bring in Debbie Lang, criminal defense attorney here in the Twin Cities. She's been watching it with us. Debbie, your assessment of the state's closing argument to the jury.
I thought the state came out strong. They came out swinging. The first 2 sentences out of the prosecutor's mouth, absolutely senseless and horrific acts of violence. All he had to do was walk away. So those are 2 very powerful sentences that are going directly towards the main defense here, which is self-defense. So I thought that was a very good strategy for the state to come out and punch hard right away. I was a bit surprised that it took approximately 44 minutes for them to really start delving into the lies that the defendant told. So I anticipate that in rebuttal, they will likely play more of those lies that Nikolai Miu told to law enforcement, because I was quite surprised that they didn't do that as part of their initial closing.
One phrase that stuck out to me that I heard several times, this idea that he was not scared, he was angry, he snapped, sort of building up this angry man getting taunted. Again, he did not excuse the actions of the teens that day to get this confrontation heated up, but again, kind of painting this man as not scared but angry. How does that play with the jury?
Well, I think that is, of course, the way that the state had to proceed. However, if you noticed, the state didn't talk about the repeated blows that are on tape that Nikolai Miu took, both when standing and then on the ground. They really tried to gloss over that and simply focus on anger, and that anger wasn't warranted. They spent over 10 minutes talking about the punch to Miss Cohen. And that was a lot of time. And I felt that they didn't then yet effectively tie in provocation with that significant amount of discussion. So I'm anticipating that the defense is going to be coming in with their closing argument, and they are going to be focusing on what happened to Nikolai Miu. They're going to be focusing on the blows that he took, the blow that caused him to actually fall back into the water, the repeated strikes when he was down, the individual pushing him from the back. They are going to be focusing on that to try to convince the jury that at that time, Nikolai Miu had a reasonable fear of death or great bodily harm.
Debbie, how did the state do in relation to all of the charges, the definitions, the jury instructions, nearly an hour long that were read to them? There are these additional counts that have been added. I believe our producer could throw up the full battery of charges Miu now faces. Because once this jury retires to their deliberation room, they get these instructions and they go, line by line. Did the state do a good job in explaining reckless homicide, why it could be that? I mean, they're asking for the top count, first-degree intentional. Did you feel, on the procedural level, legally speaking, did they do an effective job getting through all of the counts and explaining why Miu should be found guilty?
Paul, I felt that they lacked a bit in that way. As you heard, they focused a lot on specific allegations and comments. But when you look at when they actually started to cite the jury instructions, it wasn't until about the last 5 minutes. I was trying to look at a clock, but of course I didn't have a stopwatch running, but it was very late into the closing arguments. And here, these jury instructions are extremely confusing. So I expect that the defense will spend some more time with the actual instructions and take each of them and dissect them and then apply the facts as the defense would like the jury to see them to each of those jury instructions. Again, we always have to remember that the state gets to go again. They have the last opportunity to be heard. And so it could have been his strategy to wait and to not do that at this point, but to get a bit more technical once they have another opportunity. Granted, they're not going to get another hour. It will be a much shorter period of time, but I felt that the state really didn't focus enough on the specific jury instructions and applying the facts as they would like the jury to see them to those instructions.
Certainly my assessment from my vantage point, why I sort of asked that question, it just felt the getting into the definitions and the crimes. I didn't feel I got a complete story. I got a complete story on what they believe happened and why it happened, with the lies and so forth. But you are right, they do get one more chance to go. Perhaps we'll see more there. Debbie, you're a criminal defense attorney. You've gone through countless trials. I'm just wondering now, state's done. Here is your last word, 1 hour. What does the defense do? What are they doing right now? I know you've talked about taking into account what the state said, maybe, making a couple changes to what you say or what you want to emphasize first, middle, last. Take me through this moment of stress for the criminal defense attorney.
They are definitely sitting down right now and incorporating some of the things that the state said into their argument. There were some things that the state said that may have not sit well with the jury. There were times that I felt that the state was a bit flippant and, noting, it was a light touch on the shoulder and only because of dumb luck, he didn't die. And the cool, calm demeanor. I mean, they're very emotionally charged statements that I would be a bit concerned may have turned off some jurors. Additionally, I anticipate that the defense may want to address the state's comment that the teens were not unreasonable in their belief that Mr. Miu was looking for little girls. That statement struck me as odd. He then immediately went in and said that the teens were mocking and they weren't violent. But that statement is one that I wouldn't be surprised if the defense comes after. The defense certainly is going to attack the walk away theme. So they're going to be talking about the fact that Mr. Miu did not feel he was able to do so, that his party was the other direction. They were upstream, not downstream. So the defense right now is taking some of those statements that the state made and trying to weave them into their closing argument to help attack those points that were made.
Debbie, I'm going to take our camera into the courtroom briefly here. We're seeing the state seal on the second screen with Debbie Lang, criminal defense attorney, with us, just monitoring the courtroom. The judge has given the parties to 11:05 on our clock here in our Fox 9 studio, showing 11:03. So we are a couple of minutes away. Again, Carl Anderson, the district attorney in St. Croix County, elected district attorney, leading the prosecution of Nikolai Miu, delivering about just shy of an hour long, went from 9:57 to 10:53 on my count. His closing argument, asking this jury to find Nikolai Miu guilty. Debbie, I know I asked you this beforehand, and certainly it's not a scientific poll, but social media-wise today, we asked our live streaming audience with 10,000 plus votes, who's under more pressure today to deliver in the closing arguments? 51% says it's the defense. 49% said it's the state. I know you said the burden's on the state, but at least our viewers, everything's interesting to just point out. Every poll we've put out there, just everyone seems so divided on this issue, no matter how we ask, what we ask about what happened in the river that day. Defense is up. They know the jury's listening.
Absolutely. And the defense is going to focus on the presumption of innocence. And so you will hear the defense point the jury to that jury instruction. I would be shocked if they didn't do that, but they are going to want to make sure that the jury understands that that burden is on the state. I absolutely understand your viewers feeling that the defense has more stress today or more to prove. Legally, it's not the case, and the defense will try to prove and show that, or not prove, but try to make sure the jury understands that, because it is the state's burden and Mr. Mew is presumed innocent. But here, the difficult burden that the defense needs to overcome here is that Nikolai Mew lied. He lied multiple times. And so we're going to hear a lot about that in the closing arguments. At least that's what I would do if I were the attorney representing Mr. Mew here, because that is where I would have concerns that the jury is going to ignore what could be very valuable evidence for the defense and focus more on those lies.
And I suppose the question becomes for this jury, and then the state was trying to make the case, are the lies indicative that Mew knew he was wrong, that he didn't have the justification, not that he knew the legal arguments in his head in the immediate aftermath, but were the lies, he did continue them for hours, as the state said. Is that indicative in and of itself of a person who knows they did wrong or they did not have justification?
You know, an individual's conduct after an incident is something that can be considered. And so the state most certainly is going to point to that, and you can't blame them for doing that, because that's some of the strongest evidence that they have here. Again, the defense is going to try to paint this as a traumatic individual, a victim of a violent crime, as they had asked during questioning throughout the trial. And so they're going to try to paint this as someone who was traumatized, someone who was confused, and an incident that happened so very quickly that he didn't have time to process that. So they will do their best to try to dance around those lies and to explain them. And they're going to tell the jury, watch that video. The video is what mattered. You have to put yourselves in the position of Mr. Mew at the time that that force was used. And their position is that he used reasonable force given the circumstances. They'll talk about the 13-on-1, I'm sure, and that he did not have the ability to retreat. So that shouldn't be something considered to deny that his force was reasonable.
Debbie Lang, thank you so much. Stick with us. We'll come back on the backside of this. Judge Michael Waterman is back in court.